All right, let's go on the record on cause number DC 21-17517, Samples v. Roberson. Anyone here? Go ahead and make your announcement.
The record, Daniel White on behalf of defendant Michelle Roberson, who is also moving.
Okay, defense counsel. Mr. Safu, are you there? You were just here a second ago.
I'm here. So Matinda Osafo for the plaintiff, Kyle Samples, who's the non-movement in this case.
All right, let's go and proceed.
Judge, this was our motion we filed. Parties did participate in mediation, and in the process of that mediation, some facts came out that where we realized that these parties were actually, well, from our position, these parties were common law married. And so based on that, we filed this motion to abate and have since filed a petition for divorce, Dallas County District Court, that is under cause number DF 22-12754. After speaking with opposing counsel, we discussed going ahead and agreeing to this motion to abate. There's a lot of issues that if they are possibly common law married, even dealing with the children of the marriage, that could come up if this was handled here in this court, as opposed to getting a determination in terms of their common law marriage over in the district court where the divorce was filed. So based on that, there you do have a proposed order that's agreed to by both parties to abate, so that that issue can be determined over there before moving forward here.
Well, I guess why is this lawsuit even necessary?
Our position was that it was not necessary, but I think it's because the plaintiff in this lawsuit is saying that they're not common law married. So that's what has to be adjudicated over there.
Why would that have to be adjudicated in a family court?
In a divorce? It's a full divorce. I'm sorry?
Yeah, but what this is a case about apportionment of a home, is that correct?
Correct. The question is whether this home is marital property. And so now that we're saying that it is marital property, it needs to be determined, and the split, how it should be split and whatnot, should take place in the divorce proceeding.
Response?
We agreed to this motion to abate because we just want to find out what's going to be decided in the family court. But I mean, we still believe the parties are not married. So whatever is determined there is going to determine what we're going to do moving forward in this court.
I mean, I've definitely had cases before where the determination has been made in civil court that whether or not they're common law married. I guess I'm not really clear why the family court jurisdiction that was filed second, why they would have dominant jurisdiction over us. I'm not inclined to abate it. If you want to brief it, you can, but I don't see that this is something that needs to be abated at this point. If the family court judge wants to abate it and order me to abate it, I can talk to her about it, but I just don't see a reason to abate it at this point.
Judge, our only concern with that would be if the court were to make an order with regard to the property here, and say somebody passed away, there would be other issues with regard to the children and whatnot that do have to be determined in a full divorce. There's issues with retirement accounts that came up in mediation. And so there's a lot of issues that need to be adjudicated.
The only thing being decided in my court is the apportionment of the home, right? Not the retirement accounts.
Correct. But if it's marital property, our position is that it would have to go under in the divorce. What I'm citing with regard to that is put in my pleading section 7.001. It says that any division of a marital estate has to take place in a decree of divorce or annulment. And so our position is that this property could not be apportioned in to take place in something that would not be a divorce decree.
There's not been a determination that they're married at this point.
Correct.
All right. I'm not going to abate it. You guys figure out what you want to do. If you want to non-suit it, you can, or you can, if you want to go to the family court and ask, if they believe I need to abate it, I'll be glad to talk to the judge about it. This is the first filed case. There's no determination that this is, or if they make a determination that there is a common law relationship, then I'll be glad to talk to you guys about it again. But at this point, I'm not abating the case. So, anything else, guys?
No, Your Honor.
So Your Honor.
Thank you, guys. Have a great rest of your day. This case, Rhonda, just so you know, this is set for trial on 3/14/2023.
And I
Got it.
apologize.
Thank you. Okay.
Wait, did somebody say something?
I'm
No.
sorry, I have an attorney in here with me at the same time. I've just responded to you.
Oh,
You
I'm
said
sorry.
that case was set for trial?
Yeah, it's already set for trial.
Okay, good.
All right, you guys have a great rest of your day.
You too.
Okay. Our next case is Armendaris versus the estate of Juan Antonio Armendaris. Anyone here on that case?
I'm here on that, Judge. Good morning.
Good morning. Tony, let's go on the record on DC 226220 Juan Armendaris versus the estate of Juan Antonio Armendaris. Counsel, make your appearances.
Your Honor, my name is Antonio Olvera Jr. I filed the suit on behalf of Juan Armendaris and Bertha Armendaris, the plaintiff's judge.
Okay, and you want to reinstate this case?
Yes, sir. If I may give you a little bit of background, I'll be very brief. It's a
Sure.
petition for declaratory judgment concerning a property in Dallas County, Judge, that was bought some years back in the late 90s, in which husband and wife who owned this property, Judge, and purchased the property, my clients, had the son's name on the property because of purposes to get the house financed. Somewhere after that, they applied for a refinance loan. And I think the paperwork went through, but they kept the son's name on there. Since then, the son has tragically been killed in an auto accident, Judge.
Sorry to hear that.
Yeah, and they have recently tried to pay the property off and get the property in their sole name, which that was the intent between the family, but son is no longer around to sign that over. So we're asking for a declaratory judgment just to clear that title up, Judge. And the only survivor of the son is his son, who we named as representative of the estate, because we know of no one else that's ever filed an application to probate or to administer the estate in any fashion, Judge.
Okay, but the hearing today was you guys didn't show up to a DWAP and it got dismissed.
Correct, Judge. And our motion sets out the error that we did, or myself and my assistant, or not my assistant, I'm sorry, Judge, my colleague Gracie, were both in courts, and when we checked in, it was too late. Apparently it had been dismissed, and that was the error that we committed.
All right, just usually if you guys just contact us that day, you can get onto the Zoom and we can talk to you about it.
Okay.
I'll go ahead and reinstate it, but just in the future, try not to let that happen again.
Yes, sir. We filed an order granting a motion. I don't know if Your Honor can see it on the.
I have it and I've signed it. Rhonda, go ahead and put this on a DWAP in 30 days.
Okay, which,
I'm sorry?
hold on.
And so that's send it out
This one, Judge, I'm sorry, I got somebody online.
to the defendant.
Rhonda, go ahead and put this case on a DWAP in 30 days.
Got, which one was that one, Judge?
This was the motion to reinstate on the Armendaris case.
Got it. On down 30 days.
I'm sending you the order to reinstate. Just go ahead and put it, once it's reinstated, go ahead and put it on the 30-day DWAP.
Got it. Thank you.
Thank you, Judge. And Mike,
Thank you. You are excused.
thank you, sir.
Okay. So we have our next case is set for trial tomorrow, I believe. It's a pretty old case. DC 2018306 McCoon versus Lewis. Anyone here in that case?
Yes, we are, Your Honor. Plaintiffs for Richard Mann, Ted Line and Associates, and I believe there's a number of the defense attorneys here as well.
Yes, Your Honor. Stephen Compte, Kevin Yankowski, and Joey Pierkowski here on behalf of the defendants, Sunoco Retail and Derek Ray Lewis.
Anyone else here on this case?
I believe that should be it, Judge.
All right, are you guys set for trial tomorrow on this?
Fear not, Your Honor. In prior hearings, we indicated that this is likely going to be a week and a half to a 2-week trial. Your Honor indicated that you did not want to do that during this Thanksgiving weekend and asked that we come up with a agreement on a date if we wanted a special setting. So we did that and we filed that motion. That's one of the 2 motions that's before you today. We're asking for, I believe it's March 6th still. Is that right, Kevin? And
that's correct, Your Honor.
And so we've submitted an agreed motion for that date. We also have a motion to compel settlement agreements set for today as well.
Yeah, okay, March 7th for trial. Let me just see this. Yeah, we try cases on Tuesdays, not Mondays, just FYI. Yeah, that works for a special setting. That's actually a perfect time because we have a non-jury week the next week. Did you guys provide me an order on this?
I
We
believe
did, Judge.
Let me see, what day was the order provided?
Give me just a second.
Just a lot of stuff here.
Yeah, it was, let's see here. It was provided. Well, I say that, Judge. The motion was filed on 10/28 of 22. And I believe that an order was submitted at that time.
Yep, I see it. Let me go ahead and print that out.
And due to our mistake, Judge, the order will say March 6th, not March 7th.
Okay, I'll correct that. All right, guys, and then you have a motion to compel, is that right?
yes, Your Honor.
All right, and Tony, have we already gone on the record on this one?
I kind of started writing, but I didn't get the beginning of it. Sorry.
Let's go officially on the record. Let's go on the record on DC 2018306 McEwen versus Sunoco. Counsel, make your appearances.
Richard Mann, law offices of Ted Line and Associates for the McEwen plaintiffs.
Stephen Compte, Kevin Yankowski, and Joey Pierkowski on behalf of Sunoco Retail LLC and Derek Ray Lewis.
Anyone else here on this? All right, let's go ahead and proceed.
Yes, Your Honor, the reason why we're here is defendants have settled in this lawsuit with the intervener. To give the history, back in May of 2021, defendants did not want to, but Your Honor ordered them to produce all of the insurance policies that would relate to this particular instance. Defendant produced a $10 million SIR. And recently, they settled with the intervener in this particular case. In the last hearing, it was not before Your Honor, but we said, Your Honor, we don't want to waste anybody's time. The disclosures require the disclosure of settlements within this particular case. The defendants have since refused and said it's not relevant. So I guess for 2 reasons. One, in terms of the disclosures in this particular case, The underlying policy of, strategy and settlement, defendants attack that with some unrelated case law, where plaintiffs in those cases have asked for settlements in other cases. For example, they cite the case where the plaintiffs in the Ford Bronco case wanted all the settlements in other cases in the past related to the Ford Bronco, and that wasn't relevant. We're not talking about other cases. We're talking about the same cause number, this same case, and disclosures of settlement agreements. Well, what defendants are asking for is literally a rule that would make a confidential agreement between parties settling in one lawsuit. You could even imagine a mediation where, you have different plaintiffs where they come to an agreement, and then the unsettling parties, in that case, this is us, would have no idea what proceeds are left. And in that particular instance, there is Supreme Court case law that says, good cause just for knowing the insurance proceeds for settlement and litigation strategy. Well, that's the case law that's cited all the time, that Carroll Cable Company. And so there's policy reasons. In terms of if you're to go into the relevance issue, because what defendants are saying is this: when you look at 192.3, it says, and that's H, it says in disclosures, they're supposed to disclose any settlement agreements described in Rule 192.3G. That's what the disclosure rules are. When you move to G of 192.3, and it says settlement agreements. A party may obtain discovery of the existence and contents of any relevant portion of a settlement agreement. Information concerning a settlement agreement is not by reason disclosure admissible in the evidence at trial. And what they're saying is they have case law like the one I cited that it has to be relevant. I was not able to find any case law where a court ruled that just the disclosure of settlements within parties of that same litigation isn't discoverable solely for the purpose of it being disclosures. But even if you're, and you could see all the problems that would frustrate with regards to mediation and settlement if the court was to make that rule. But even if you were just to go to relevance and we were to actually play this game, an eyewitness to the case, the motorcycle who's right next to the vehicle my plaintiffs are in, has received a sum of money and he's still on our witness list against the defendant. And that would directly affect or could affect his motive for testifying one way or the other. And so if you're just to go to the plain disclosure rules that we use all the time for the purposes of settlement and knowledge of insurance, and to actually give meaning to those rules, I mean, the purpose of disclosures is frustrated if you were to go with defendant's interpretation. But even if you were to set that aside and go to the meaning of the word relevance, it is relevant if a party or a witness is receiving amounts of money not to testify, or possibly would be affected, their testimony would be effective in terms of their motive. And so, Your Honor, whether you go the one way or you go the other way, in this particular instance, a confidential settlement between the intervener and the defendant is discoverable. And so that there's no miscommunication, we have agreed that in terms of there being, we're not saying we're going to put this on Facebook or anything, we're saying confidential, we're agreeing to the protective order that's already in place. And I'm going to spread it to some other non-party, but that is not good enough. So that's our argument, Your Honor.
Now respond, Judge. You're muted, Judge.
Go ahead.
Okay. Thank you, Judge. I do think that Mr. Mann correctly points out the issue is, what does Rule 192.3 require? The legislature could have very easily promulgated that all settlement agreements are discoverable, or the amounts of settlement agreements are discoverable. They didn't do that. They said the existence of the settlement agreement, which we've disclosed, and the contents of any relevant portion of it. And the issue of what is relevant comes down to, Rule 401 tells us the definition of relevant evidence is any evidence that has a tendency to make a fact of consequence to determining the claim more or less probable. The plaintiffs, to prove their case against the defendants, have to prove duty, breach of duty, and harm. That's it. The amount of the settlement agreement that we entered into with an unrelated third party, Mr. Hammond, doesn't make any of those facts of consequence more or less probable. It's not relevant to their case. Now, can there be situations in which the amount is relevant? Yes, Judge, there can. We have a situation like that in this case as it relates to the settlement between the plaintiffs and their co-defendants, Design, Transport, and Sherry Caps. The plaintiffs settled with the co-defendants, which would make that settlement amount discoverable to the defendants because we have a settlement credit or an offset that we're entitled to in the case. So in that instance, an amount is clearly relevant because it affects how the case actually gets tried, how the case gets presented to the jury, and how damages ultimately get awarded. That's not what we have in this case. The amount that we paid or agreed to pay Leroy Hammond has no bearing on any claim that the plaintiffs have against the defendants in this case. And the courts in Texas, in looking at this issue, 14th District Court in Houston and Paladero Pipeline, which we cited in our briefing, said that determination of the amount of one settlement agreement so it can be used as a quote unquote comparative bargaining tool, that's not proper. And the plaintiffs in their briefing really didn't set out any reason why it was relevant. The reason that I heard in the argument was that, well, I guess maybe Mr. Hammond in his testimony now he would be biased because he received a settlement from us. Mr. Hammond's already been deposed in the case. Plaintiffs had before the settlement. Plaintiffs had full opportunity to develop the facts with him at that time. He didn't say anything beneficial to the defense, obviously, in the case, because he had his own claims against us at that time. The idea that he's, I guess, going to completely change his testimony now that he's received a settlement agreement and testify favorably for us is pretty far-fetched. If that occurred, I guess, at the trial, then maybe the amount of the settlement becomes relevant and maybe it becomes discoverable at that point. But at this point, as we sit here right now, it's not relevant to any issue in the case. It's therefore not discoverable following the precedent, one, the plain language of the rules in Texas, and then the precedents from the 14th Court and then the Texas Supreme Court in the Ford Motor Company versus Leggett, where the court said, look, determining the amount of the settlement to use for your settlement strategy is not a proper use of discovery. And understand there are some factual differences in the Ford case. In our case, it doesn't change the fact that the rule says any relevant portion, which in and of itself means that there are portions of settlement agreements that by their nature are not relevant. And if the legislature wanted to say you have to disclose the amount of the settlement, they should have said you have to disclose the amount of the settlement, or you have to disclose the entirety of the settlement agreement. That's not what the rule says. The rule says any relevant portion. They failed to show why the amount is relevant to their case. And that for that reason, Judge, we would ask that the court deny the motion. They've also asked that costs be assessed against us. We would ask if the court does rule against us, you deny that request because we do have, I believe, good faith arguments based on the language of the rules and the precedents.
All right, well, good. Well, I'm going to go ahead and rule in favor of the plaintiff on this and order that the amounts be disclosed within 7 days. I'm not going to award costs.
Okay, Judge.
All right, guys.
You-
So much. Have a great rest of your day, okay?
May I make one more request, Judge?
I've got like 8 other hearings. What do you need?
Yes, sir. In our motion, we asked the court would consider staying the ruling for 30 days to allow us to seek the appropriate appellate relief.
You have 7 days. Good luck.
Thank you, Judge.
Thank you.
All right, you guys have a great rest of your day, everybody.
Appreciate it. May we be excused?
You may. Our next case is Sanchez v. Encore Electric Delivery Company, DC 223628. Anyone here in that case?
Yes, Your Honor.
I'm here for that case, Your Honor, for the plaintiffs.
Is
Yes, Your
anyone?
Honor. I'm here with defendant Zio Group.
Okay.
And Your Honor, I'm here on behalf of not Encore, the Hildebrand and sorry, MM Legends. Hildebrand is Encores. Keep forgetting.
Okay, let's go on the record on DC 223628 Sanchez versus Encore Electric Delivery Company. Council, make your appearances.
Jessica Gonzalez for Plaintiff Sanchez and Ayala.
Lance Travis for defendant Encore.
Jennifer Morrison for defendant Zio Group.
Larissa Prilliman for defendant MM Legends Crossing.
Vance Metcalf for defendant USIC Locating Services.
All right, let's go ahead and proceed.
We're hearing my motion first, Your Honor, the deemed admission.
Yes.
Okay. Yes, Your Honor. So we filed this motion to undeem admissions. A defense counsel, I believe Mr. Lance, had contacted my office and made us aware that there were some discovery responses that we hadn't responded to, including some admissions. As soon as we became aware that there were admissions, he mentioned his intention to file a motion for summary judgment based on these admissions. We immediately we had the clients in that weekend already to go over a discovery because there were several discovery sets from the different defendants. We sent those admission responses to MM Legends and to the Encore defendant and sent them the rest of the discovery. There's still some other pending discovery for some of the other defendants. But as soon as we found out that these admissions weren't responded to, we responded to the admissions and then immediately filed this motion to undeem admissions. Defendant then proceeded to file a motion for summary judgment based on these deemed admissions. And so we're here before the court. This case is still a fairly new case. We haven't even done depositions. I think our admission responses were right around maybe a couple weeks late, a few weeks late. And so we're asking the court to undeem these admissions.
Response.
Your Honor, on behalf of defendant Encore, just a couple of clarifications to what was said. Plaintiffs did not immediately respond to the request for admissions when they were notified they were late. This is not a case where we laid behind the log. I started emailing plaintiffs' counsel the first morning that these admissions were overdue, asking them if they intended to respond, and if so, when they intended to respond. They completely ignored 6 emails over the next 2 weeks. Again, following up, asking them if they intended to pursue the case, what was going on with the discovery. Some of this discovery had been overdue, including the disclosure responses had been overdue for 5 or 6 months. And multiple defendants had been reaching out to plaintiffs' counsel, trying to find out what the status of this discovery was and getting absolutely no response from them. So actually all of these motions, including the motion for summary judgment, was filed and sent to plaintiffs' counsel before we ever even got a first response back from them about any intention to respond to anyone's discovery or even pursue the case. They did finally respond, and we had a motion to compel set this morning on, I don't know, 6 or 8 or 10 other sets of discovery, which they did respond to in the last 48 hours. So they basically mooted most of the motion to compel that the defendants had set for later today. But on the admissions, they are late. They did not remedy their mistake anywhere near immediately when they were notified of their mistake. And to this day, they have not articulated any good cause, not said it in any pleading, nor provided any proof of any of the legal standard of good cause of why these admissions ought to be undeemed. And so that's the basis of our position, Your Honors. There's legions of case law talking about circumstances in which admissions should be undeemed when parties did not timely answer. They involve problems with service, which there were no problems here. We've got proof attached to all of our motions that they opened the request for admissions on the day that they were served, and then they simply failed to respond. And after repeated attempts to find out why they failed to respond, they sat silent. And then when they finally did respond, they articulated no reason why they were late. And so under those circumstances, they've not met their burden to establish good cause under any of the controlling case law, and the admission should stand.
And Your Honor, on behalf of defendant Legends, since we also have a motion to strike deemed admissions against us as well, I would add on to that. Again, I agree with most everything Mr. Travis has said. I would simply add to it that this case is not brand new. This case was filed back in April. And since the time that defendants have answered the case, we have been attempting to get in contact with plaintiff's counsel over and over and over. So the fact that she pointed out that depositions have not occurred, I have no idea how they could have occurred since we didn't even get discovery. There's no way we could have set up a deposition since we hadn't gotten anything from the plaintiffs. And even now, since they finally responded to our discovery just on, we got our responses on Thursday and Friday to ours. And we still don't even have all of the medical records, all of the billing records. We don't have any information on the, what they're claiming for lost earnings or anything like that. There's still all sorts of documents that the response is will supplement. It's just on and on and on. I would say that in these circumstances, the proof, the evidence shows that their response is not only overdue, but they have callously disregarded the discovery rules in this case, particularly since they actually responded to my request for the overdue disclosures. And they said, oh, well, yeah, I'm so sorry. We'll get those to you in a week. That was back in June. And we did not receive them. And they did not respond to any follow-ups of, hey, you said you'd get this to us in June. We still don't have them. It required a motion to compel.
Let me ask, when were the requests for admissions due?
With respect to Encore, Your Honor, October the 6th.
They were 13 days late. I mean.
And then what about for your client, Ms. Perlman?
Ours were a little bit more late. Ours were due, trying to look specifically.
But Your Honor, I mean, we're here on the admissions, not the rest of the discovery. And I've sent all the documents that I have in my file, all the affidavits that we have. So I've sent everything to Legends and Encore. We're not here on these other discovery issues. We're here on admissions. And like I said, I served those as soon as I was notified of it through Cassandra. And so I got those over as soon as I could.
And Your Honor, the answer is September 28th.
And Your Honor, we were emailing plaintiff's counsel that's on the hearing today. All those emails are attached to our response. We were emailing her every day for weeks, and not only not getting responses to the admissions, but not even getting a response to the email letting us know what was going on or what their intention was. And like I say, when they did respond, and even today, I have not heard counsel attempt to articulate good cause.
Yeah, I guess, Ms. Gonzalez, why did this happen?
It was a mistake. I mean, and that's enough. That's enough of on my end to prove. I mean, I didn't see it. Once I became aware of it, I responded to it. I mean, the discovery, it wasn't set as a whole packet either, right? And so I think that's probably why I did not see the admissions where they were separate in separate envelopes. It was not intentional. I mean, I wouldn't intentionally just disregard requests for admissions.
Your Honor, we have proof that they opened the envelopes, and we also have proof that we emailed them repeatedly with no response, and they haven't proved at all still with what she said today about what the quote unquote mistake was. And the case law does not say that every mistake is excusable. You can make mistakes that are in callous disregard for the discovery rules, and that appears to be what happened here.
And Your Honor, I would also like to point out that although Ms. Gonzalez may claim that she apparently was not reading her emails and apparently not paying attention to discovery, but the onus is not just on her alone, it is on their firm, which is representing plaintiffs. So it is also on Cassandra.
So who opened the email, I guess, and Ms. Gonzalez, was it you or somebody else opens them for you, or kind of, I guess they say you opened the email, but then you didn't respond.
Typically, well, it was sent to service@oakclifflawyers. I mean, that is an email address that is accessed by me, Cassandra, but it's also accessed by our two new staff that we have. And so they check our emails there and try to calendar everything. That way we can try to not miss things like this. They're still fairly new. And so we're kind of, maybe it was an oversight on their part. Maybe they're the ones that opened it. I know that I didn't personally open it.
Your Honor, I would point out that our requests for admissions were served back on August 29th. So I'm not sure if there's new staff. I don't know.
Either way, I mean, the responses to MM Legends were 21 days late, and the other ones were 13 days late.
But Your Honor, more than just the service emails, we do have their personal email addresses. I mean, their work email addresses, and that's how we've been attempting to confer with them on all of these matters. And we sent multiple emails to both Ms. Gonzalez and her co-counsel, starting immediately on the day that these were due, asking what was going on. And it took 7 emails before I got a call from her partner saying that they were late and would try to get things to us as soon as they could. Even in that phone call, and again today, nobody tried to tell me why they were late, other than they had just ignored our requests.
And Your Honor, the case law, which has been cited by both Mr. Travis and I, both points out that there has to be some kind of evidence, because she is right that simple mistake will excuse it, but there must be some type of evidence that this was a mistake. There is no affidavit, there's no even declaration, there's nothing in their motion that evidences this fact.
Well, I mean, I wouldn't represent to the court that it was a mistake if in fact it wasn't. And I don't think the motion requires for me to have a verification or an affidavit attached to it.
The case law actually does require that, Your Honor.
I think he's actually right about that. I guess my question is, and
my apologies,
Mr. Travis and Ms. Perlman, I mean, I understand your frustration. I totally get that. It's you're just trying to move the case forward, which is exactly what you should be doing. But there's 2 ways we can handle it. I can reset this so that Ms. Gonzalez has an opportunity to submit an affidavit. I will tell you my normal approach to this, and this is what I would probably do here, is that, I don't generally, if I give kind of people a shot, and then if they show a pattern of discovery abuse, and this would definitely be a red flag, what's occurred so far is not so much missing the deadline, but the fact that they ignored all those emails. I don't anticipate I anticipate I would probably grant the motion to strike eventually if it's put in the correct format. So if you want her to jump through that hoop, that's okay. And I wouldn't blame you necessarily if you did. I just want to tell you that ultimately what I usually do is give people a chance. They make a mistake. We all make mistakes, but it becomes a pattern, and then we take more severe more severe approach. And so do you want her to kind of jump through the hoops, or do you want me to just go ahead and grant it today?
Regardless of whichever way Mr. Travis says, I would simply ask that the order have some kind of note in there warning plaintiff's counsel about future issues of this type.
Okay, Mr. Travis, that's fair.
That's fair, Your Honor. And I have a motion for summary judgment set for Friday that is based entirely upon the deemed admissions, which I will withdraw and cancel at this time.
All right. And Ms. Gonzalez, you guys, you guys have got to do something about this because we've had issues like this in other cases, not this exact issue, but just DWAP, missing DWAPs and stuff like that. You gotta get on this. And so, but I will put a notation, plaintiff's counsel admonished about late filing.
And Your Honor, we will attempt to continue to work with them really in what we hope is what the court would consider a reasonable manner. But at this point, we're just trying to gather initial information so that we can take some of these party depositions and find out what the case is about and move it forward. And so we may be back. We'll give them a little while longer to get us complete discovery responses, but we may be back given how long these responses have been pending and the fact that they're still incomplete. So we won't come back next week. We'll give them a little bit of time to get their act together before we refile a motion to compel, but we do need to get complete responses to these things that have been months overdue and be able to move the case forward.
I fully understand that, Mr. Travis, and I respect that. So
thank you, Your Honor. Appreciate your help today.
All right, let's get this case moving and let's get it on track. So you guys have a great rest of your day, okay?
Thank you, Your Honor.
Your Honor, this is Vance Metcalf for USIC Locating Services. I believe we had a motion to compel, a joint motion to compel set for 9:45 a.m. this morning. And plaintiffs have still not responded to USIC's interrogatories or requests for production. They did serve some discovery responses last week, but not to our client. And those were served back in June of 2022.
I can't tell who's speaking. Who is speaking right now?
Vance Metcalf for USIC.
Oh, I see. Okay, sorry. Say that again.
So we served discovery interrogatories and requests for production on June 13th, 2022, and I have not received any responses to USIC's interrogatories and requests for production.
And I was planning on getting those out to you today. I'm almost completed with those. I've just been trying to work through the discovery sets as the ones that were served initially, like first, and then so I am getting those to you, and I can give them to you by the end of the day. If you need an order or what have you, then I'll agree to that.
Your Honor, I don't need an order. If we receive the responses later today, then there's no need for me to submit a proposed order.
If you do want an order on that, Mr. Metcalf, go ahead and email it to Rhonda. Make sure it says at the beginning, excuse me, that this was heard on November 14th, 2022, and email it to Rhonda and e-file it. We'd be glad to sign an order on that. And if you don't need an order, that's okay too.
Yes, Your Honor. Thank you.
Thank you, guys. You have a great rest of your day.
Thank you, Your Honor. Good to see you.
Thank you.
Good to see you. Okay, busy morning. Next case is Almares versus Dials. Anyone here in that case?
Todd DeBose for the plaintiffs, Your Honor.
And Malcolm Rennick for the defendant, Your Honor.
All right. Have you guys reached an agreement on the trial setting on this?
We have an agreed scheduling order was submitted, I believe, Friday afternoon. It looks like it's still in queue on e-file.
No, we just got that in. I will go ahead and sign that and get it in. All right. Anything else, guys?
Malcolm, did you have a motion to consolidate? It was my understanding that got sent to you, Judge, out of the 44th.
Right. It's supposed to go back into the 44th. That was the older case. And she sent it to you and we didn't understand why.
Oh, I don't know. I have not talked to her about that. So who has the older case?
She does. The 44th.
It should go to her then, right? what do y'all want me to do? Do you want me to vacate her? I mean, I would go to her and just say, hey, look, it's supposed to go to your court. I don't know why she said it to me exactly, but
yeah, it shows she forwarded it to you on November the 4th. And so
if she has the older case, she's the one that should be signing it and she should be sending it to her court.
yeah, we all agree on that. So we'll try to get her to sign it and get it back to her court.
Okay. Sounds good. Anything else today, guys?
Nothing, Your Honor.
Nothing here. Thank you.
All right. Have a great rest of your day.
You too.
You too.
Okay, our next case is at 10 o'clock. Case. Maldonado versus Hernandez, DC 222346. Anyone here in that case?
Yes, Your Honor.
Who's that?
Maria Sevis, the guardian ad litem, and plaintiff's counsel and defense counsel are on as well.
And this is on Maldonado versus Hernandez. Okay, what's going on with this one?
Well, good morning, Your Honor. This is Garrett Mize on behalf of the plaintiff. In this case, a friendly suit, we are working towards setting a minor prove-up hearing as soon as possible. But what we're working on at this moment is primarily one large reduction that we have requested from Medicaid. This is a minimum policy limits case. There is a settlement in place, but in order to make this settlement as favorable as possible for our minor client, we are working to reduce Medicaid's $30,817.90 lien. To date, they have agreed to a 17% reduction, which is what they will customarily offer as an initial offer. We have worked graciously with the guardian ad litem to send a letter to Medicaid. We've sent with her 2 letters to Medicaid. She has sent those on behalf of the minor to encourage them to consider a more favorable reduction. At this point, we have succeeded in getting them to escalate this to the state level, so the people with the most authority at Medicaid. In my experience, once we finally get to that level of review within Medicaid, we're able to make more headway and more progress. So we've recently submitted a request with additional information asking that they offer a serious and more a greater reduction. And once we do that, we should be able to make the numbers work for our client. But we're now pending their response to that.
Okay.
Yes, Your Honor, and just for more clarification as well, I've also been in contact with Medicaid. As plaintiff's counsel indicated, I've sent 2 Alburn letters requesting reductions. As the court was notified, there is a $30,000 policy. Medicaid is going to collect around $23,000. As that stands, I can't approve the settlement. It's not in the best interest of the minor. And so we wanted to have this status conference to give the court insight as to what's going on with the case and Medicaid's refusal to reduce their lien after numerous requests from plaintiff's counsel as well as myself.
Okay, I know, Ms. Savis, that you're getting a little concerned about having any more of these guardian items pending. Do you want to stay on this for a couple more weeks just to see, or what do you want to do?
Sure, Your Honor. As the court is aware, I do have a little bit of a time frame situation. So I'm happy to stay on or roll off if that's what the parties prefer. I do, like I said, it's just without that reduction, I don't think that this can be, I just don't think it's in the child's best interest without getting a significant reduction from Medicaid.
Okay. One thing I've done before, and it's been a while, is do we want to go ahead and, at the next hearing, go ahead and have Medicaid attend it?
In one of the Alburn letters, I did notify them of this actual hearing that we're having today, and send them the information. But yes, whatever the court thinks would be the most.
Is there anyone here from Medicaid?
No, Your Honor.
Okay. Mr. Mize, Mr. Alexander, what do you want to do?
I guess let's give Medicaid a shot, Your Honor. I'm not quite sure what we can do if Medicaid is not going to agree to reduce. I don't know what else the guardian is going to want us to do to satisfy, I guess, her opinion on the matter. And it's a $30,000 case. The policy's been offered, and my clients are judgment proof, so they have no assets. So it is what it is.
Your Honor, my preference.
Yeah,
Go ahead. I'm sorry.
I just can't approve that. That's not in the best interest of the minor. So, I mean, until we get some type of traction from Medicaid, I'm not approving a $23,000 Medicaid lien on a $30,000 policy.
It makes sense.
And Your Honor, I agree with the guardian ad litem, that this is not in the best interest of the minor at this time. We need Medicaid to cooperate with providing a reduction. And, in my experience in prior cases, I've always been able to get them to do that, to see the light. Sometimes it does take multiple requests and iterations of reduction negotiations. So my hope would be that we allow Medicaid, at least one additional time to respond, since we have now escalated it to the state level. We recently submitted that information to them. I would suspect that within the coming, month, 2 months, at most probably 3 months, we should expect a response from them. It is difficult to determine the amount of time that they will take to respond. But my hope is that in the coming months, they will provide a favorable response. Because usually once it is escalated to this level, they do review the circumstances, look at the injuries, look at the finances and the math, and provide a better response. So that would be my suggestion, to allow Medicaid time to respond to our most recent request to their state level authority to decision makers.
And I'm fine with that, Your Honor. If the court is so amenable, I'm happy to roll off the case before I get sworn in. So whatever.
Why don't we do you want to just wait to figure that out? And if they come back in the next month or so, you can stay on. And if not, then we'll go ahead and replace her. How does that sound, guys? And Mrs. Davis?
That sounds fine to me, Your Honor, if the parties are agreeable to it.
Mr. Alexander?
I don't have a problem.
Mr. Wise?
And that would be fine with me, Your Honor.
Okay, just make sure you let me know and get me a request for a substitution if we get to that point.
Thank you, Your Honor.
All right, you guys have a great rest of your day, okay?
Thank you, Your Honor.
Take care.
Thank you, Judge Hoffman. You as well.
Thank you for the update. All right, our next case, I believe, well, a busy morning. David Rodriguez versus State Farm Mutual Auto Insurance. Anyone here on that case?
Mary Jo Betson here for plaintiff David Rodriguez.
Anyone here for the defendant, State Farm? All right, have you guys discussed the trial setting for this?
Is anybody here on for State Farm?
I don't think so.
Okay, Your Honor, what's going on in this one is our client settled with the underlying tortfeasor, and we have a claim against State Farm for his UIM. Apparently, the defendant, the underlying tortfeasor, has also sued our client in a different and older case. So I think this case is going to be consolidated into that one.
Okay. We still need to set this one for trial, and then if it gets moved, it gets moved. So when do you want to set it for trial?
I believe our office was asking for dates in March 2024. Is that too far out?
2024. Okay, that's a ways off. Yeah, let's do a little sooner than that.
December of this year or next year?
Yeah, December of next year works. Let's see. How about December 5th of 2023?
That will work.
And who do you want as the mediator?
Adam, we like Adam LaCrone,
Okay.
if that's fine.
Rhonda, go ahead and set this for trial on December 5th, 2023, and put Adam LaCrone as the mediator, okay?
Got it.
All right. Have a great rest of your day. Just whoever that has the older case, go ahead and whichever judge has that, just request a consolidation and they can take my case away.
Okay. All right. Thank you, Your Honor.
Thank you. Have a great rest of your day.
Am I excused?
You are excused. All right. Next case is okay. Moreland versus Carranza. Anyone here in that case?
Yes, Your Honor.
Yes, Judge, here for defendant.
All right, what's going on with this one? Or when do you want to set this for trial?
We just got an ASO agreed to this morning and have just filed. It looks like we've got a September 19th trial date we've agreed to. And so that should be coming through sometime this morning.
Is that correct?
Yes, Your Honor, that's correct.
Rhonda, go ahead and set this in. Did you put in a mediator?
We did. We chose Mike McCullough.
So Rhonda, if they haven't set that in yet, go ahead and set it on September 19th, if that's whatever that Tuesday is, and then put in Mike McCullough as the mediator.
Got it.
All right. Have a great rest of your day.
Thank you, Judge.
Thank you.
You guys are excused. Coyle versus East Bay Inc., DC 191235. Anyone here in that case?
Yes, Your Honor. Michael Donahue here on behalf of the plaintiffs, John A. Coyle.
You need to turn on your video.
Your Honor, Dennis Racine on behalf of Trey Black, and Trey Black is here as well.
Frank Cram on behalf of the defendant, Your Honor.
Okay. Let's go ahead and go on the record then. Let's go on the record. Tony on DC 191235, Coyle versus East Bay. Counsel, make your appearances.
Your Honor, Dennis Racine on behalf of Trey Black, the movement.
Michael Donahue here on behalf of the plaintiffs, John A. Coyle.
Frank Cram on behalf of defendants, John K. Coyle.
Is that everyone?
I believe so.
All right, let's proceed.
All right, very well, Your Honor. We have in this case, the court may not have seen all of the progress, but the court did confirm the sale. I can advise that the sale of the property here has occurred and been closed. And the next steps in the case are to put in a final fee application and move for a discharge. So we're right at the end. This is an interim motion for approval of the fees that have been identified. I believe it's unopposed. And so that's where we stand at this point. There will be those couple of housekeeping items at the very end, but we're pretty close here. And this particular motion it involves the fees that have been incurred through the date of the application. There will be one to follow.
Any opposition?
Not from the plaintiffs, Your Honor. We're in agreement.
Not from defendants, Your Honor.
All right, we'll go ahead and sign that. And thank you for your service, Mr. Black. And we'll get this signed and sent in today.
Thank you, Judge.
Very well. Thank you, Your Honor.
Thank you.
Have a great rest of your day.
Thank you.
You too.
Okay, let me get to the next case. Is everyone here on Nemens versus Dallas Area Rapid Transit? Everyone here on Nemens versus Dallas Area Rapid Transit?
Good morning, Judge. Plaintiffs are present.
Defendants? Anyone here on for the defendants on this case? It's not quite time yet, so we're going to give a few minutes.
Connor, this is Laura Lewis. We think we're here for a 9 o'clock hearing as well.
A 9 o'clock hearing?
Yes, on the default judgment in against Rodney in the Diversitas versus Circle M Rodney Murphy case. I think Judge Metcalf asked us to be here.
Okay. It's not on the docket. Let me pull that up. What's the cause number?
We'll get it for you, Judge. Cody, you have it handy?
It's DC-21-15241, and I'm Rebecca Brown for plaintiff, Your Honor.
Thank you, Rebecca.
Of course.
And what is set for today? We have a motion to withdraw set on November 21st. I think that's maybe the confusion. It's on the 21st.
Oh, we all thought it was today. I'm sorry.
So per Judge Metcalf's email with Ms. Pinson that was forwarded to us, it looked like we were just told to jump on the docket for today. But I did look on Friday and saw there was a notice in there setting it for the following Monday. So I just jumped on to make sure there was, you know.
We have it for both days.
Yes.
Did you put the client on notice for the hearing today?
Actually, Your Honor, this is just a bizarre thing in that we accidentally filed our answer and it said all defendants, but we only represented one defendant. So the next day we filed another answer saying we don't represent both defendants, we only represent one. And so the one unrepresented defendant has never answered. And we're just trying to make it clear to the court that I sent in an affidavit too.
No, that's okay. Did you put, it's Murphy, right? The defendant Murphy?
Yes.
Did you put defendant Murphy on notice of this hearing?
Nobody can reach defendant Murphy. He's never been served. We don't know how to get a hold of him.
Do you have a last name address?
Oh, he served.
Yeah, that's why we filed the default, because he was in fact served. But the court would not rule on our default because of that previous answer that was filed. So the record indicates that he has counsel. And that's why it was my understanding. That's why Ms. Lewis had filed the affidavit stating she didn't represent him, and hoping that that would be sufficient for the court to remove them as attorneys of record.
Okay, so let me just I think something's been lost in translation, just so we're kind of all on the same page. So I want to make sure that Mr. Murphy is notified of the hearing next Monday. So make sure that whatever his last known address is, or if you have an email or whatever, that he is notified that this hearing is going to take place. I'm sure it's not going to be an issue, but in an abundance of caution, because I have been burned before when I'm like, oh, this is probably not a big deal. I want to make sure Mr. Murphy has due process here. And if he may have some other understanding. Maybe he thinks that you are, I don't know any of the details. So just make sure he's notified about the hearing next Monday. and then I'll take care of it next Monday.
Okay, thank you.
Thank you, guys. Have a great rest of your day.
Bye-bye.
You as well. Thank you,
You may
Judge.
be excused.
You may.
Thank you.
Okay. Are both sides here on the Dart case? Nemens versus Dallas Area Rapid Transit, are both sides here on that?
Dart is here, Your Honor. Here for plaintiff, Judge.
Okay. All right, let's go on the record on DC 204588, Nemens versus Dallas Area Rapid Transit. Council, make your appearances.
Melissa Webb with Castle Law for plaintiff Charles Nemens.
Ashley Ramos for Dallas Area Rapid Transit, the defendant.
Let's proceed.
Your Honor, this is a motion for summary judgment, no evidence. As you recall, this was originally set back in October, I believe it was October 28th, got reset until today. Your Honor, plaintiff filed an amended response, which was on Tuesday, which is late for the 7 days filing. They filed their amended response on Tuesday, November 8th. And therefore, any amended response should not be considered. If you do consider it, however, there is still no evidence that plaintiff paid the fare for a train fare in the day in question, or that the train station itself was paid for any fees, and therefore plaintiff is a licensee. Other than conclusory statements in plaintiff's response that he paid for to be at the station, there's no genuine issue of material fact and no evidence to support plaintiff's assertion that he paid for a fee to use the premises. And this court has no obligation to consider conclusory statements, as a conclusory statement is not sufficient to raise a fact issue. Hovorka v. Community Health Systems, Inc., 262 Southwest 3D 503, Texas Ave, El Paso, 2008. Additionally, Honor, there are some issues with what plaintiff is asserting in the evidence that they have attached, specifically in Exhibit A. Plaintiff attempts to assert that this is the portion of the transcript where the plaintiff says that he actually paid for a train ticket to access the premises. That is not present in Exhibit A within that entire exhibit. And as you know, Your Honor, when the plaintiff's status is in question, it is the plaintiff's burden to establish whether or not it's an invitee or a licensee. Additionally, Your Honor, plaintiff asserts that because there are listed customer features on the DART's website, that therefore DART is in control of that website. There's no evidence. Exhibit C does not have conclusory evidence or any evidence that DART actually owns the station, Your Honor. And if I want to go back to that, the courts have held that the payments of fees merely related to the premises are not payment for use of the premises. You can see State Department of Highways and Public Transportation v. Kitchen, 867 Southwest 2D, 784 Penn Site 786 Texas 1993. Payment of a vehicle registration and licensing fees was not payment for use of the public roadway. You can also see Garcia v. State, 817 Southwest 2D, 741 Penn Site 743 Texas Ave, San Antonio, 1991, where the court held that payment of fuel taxes was not payment for the use of public highways and did not confer invitee status. Additionally, you can look at Simpson v. Harris, 951 Southwest 2D, 251 Penn Site 253 Texas Ave, Houston, 14th District, 1997. The court held that payment of filing fees was not payment for use of the courthouse premises as contemplated by Section 101.022 of the Texas Tort Claims Act. An appellant was
Are
not.
any of these cases, you've been kind of going through them kind of quickly, are any of these cases involving the use of like a bus station or train station?
There's not specifically one on that point, Your Honor. I think the one that's most analogous, I believe that the court's issue last time was whether or not DART owned the station. I believe that the Simpson case regarding the courthouse and paying on the filing fees, those are both government entities owning that premises, and the use of the payments of fees related to a premises are not payments for the premises itself. Additionally, Your Honor, plaintiff has not provided any evidence that the condition presented an unreasonable risk of harm. The only thing that's been presented was that there was 8 inch or so difference between that. Additionally, in Exhibit D, which is the evidence regarding that specific element, plaintiff states that he did not step correctly, which contributed to his fall. Additionally, plaintiff has not provided any evidence that DART had actual construction knowledge of the condition. And additionally, plaintiff has not provided any evidence that DART failed to exercise ordinary care to protect the plaintiff from danger. And as such, defendant's motion for summary judgment should be granted.
Response?
Yes, Your Honor. Essentially, and I'll break down each of the elements as they were. Evidence of each was provided in a plaintiff submitted response to defendant's motion for an evidence summary judgment. But essentially, the defendant is relying on a distinction which should be within the purview of the jury, and that is whether or not Mr. Neiman's was in fact an invitee versus a licensee. We assert, and I believe that the evidence contained within the motion would show that Mr. Neiman's was in fact a licensee, or at a minimum presents a genuine issue of material fact to be presented to the jury about whether or not Mr. Neiman's was an invitee rather. That evidence is included in Exhibit A as well as.
Where does it, can you quote for me from Exhibit A where it says that she paid the fee?
Yes, Judge.
Maybe I missed that.
And in Exhibit A, it creates more of a, I would say, a body that goes beyond an inference that a reasonable person could surmise. I'm pulling the exact quote for you, Judge.
Tell me what you're talking about.
I believe in Exhibit A, he's explaining that he takes this as routine travel to work, that this is the way that he commutes to work. And then in Exhibit Pardon me, Judge, I'm hoping I didn't staple my document out of order here.
Okay. So what page is it about the
I'm concerned that the the incorrect pages, the excerpts from the transcript were included in plaintiff's exhibit A. The language that I'm looking for describes that Mr. Neiman's uses the Galatian station as his stop, the end of his stop on his commute to work, that he's a daily rider, and that he regularly and routinely pays a fare. There is not, and plaintiff doesn't mean to assert that he specifically stated that on that day he paid a fare, but there is no evidence that on that day he didn't pay a fare. So there was evidence contained within what should have been Exhibit A that he routinely pays a fare when he uses the DART to commute. And I'm looking at D and E to see if perhaps those were attached out of order. I apologize, Your Honor. It's my apologies to the court, Judge. It's not contained within the exhibit as it's included in plaintiff's amended motion. It is contained within the transcript of Mr. Neiman's deposition, but it is not contained within the exhibit as included in this motion. The defendant is not incorrect, and I'll concur that there is no evidence specifically that Mr. Neiman's paid a fee on that day. However, the evidence from the deposition did indicate that he was a daily commuter to his job that was located near the Galatian Park station, that he routinely paid a fare. And there was no evidence to indicate that he did not pay a fare on the day of his fall. Moreover, again, I think that that does raise a genuine issue of material fact to be presented to the jury as to whether or not Mr. Neiman is an invitee over a licensee. As for the case law that the defendant relies on, I think it's both factually and legally distinct from the setting here. Defendant agrees that the DART train itself is part of the premises that a fee would cover, but sort of invents this imaginary line, making the train itself distinct from the platform. We're not talking about a parking lot. We're not talking about a public building that's otherwise open, such as a courthouse where, there might be associated fees for doing business, conducting business within that building. This is the platform onto which any rider would step on coming off of the train. Evidence included in plaintiff's exhibit C from DART's website lists specifically that features of the Galatian Park station are customer features. A plain understanding of the word customer means a person who conducts business with or pays a fee to use a good or service. On this day, Mr. Neiman's was a invitee by virtue of his train fare, which allowed him access to the trains and buses that he rode to the Galatian Park station. And that platform is part and parcel with the service that DART provided in exchange for that fee. Had Mr. Neiman's not paid that fee, and been hanging out on that train station platform, he very well could have been criminally trespassed by the DART Police Department. It's that fee that gives customers and riders the right to be present on the platform, both before and after their journeys on the DART train itself. As to the other elements regarding the defect, Mr. Neiman's did testify that there was a 1.5 to 2 inch inconsistency or break in the concrete as was present on the platform. He also testified in regards to constructive knowledge, which would be the standard we were looking at should the jury find that Mr. Neiman's is an invitee, that the platform, he routinely observed it almost every other day being cleaned up, but that on the day in question of his fall, that there was a lot of trash on the platform and he did not observe what was the normal and routine cleanup crew. So there is at least more than a scintilla of evidence there for there to be a genuine issue of material fact as to whether DART should have known that there was a defect and that it was unreasonably necessary. With the evidence presented vis-a Mr. Neiman's deposition on his testimony and the facts presented therein, there has been a genuine issue of material fact as to each of the elements under the theory that Mr. Neiman's was an invitee. However, should the court find that he was not an invitee, I'd submit to the court, Your Honor, that at a minimum, that in and of itself is a question of fact for the jury to decide, and that there has been evidence, more than a scintilla of evidence produced for the jury to have a reasonable question or a genuine question of material fact as to whether or not Mr. Nemens was an invitee. And on that basis, Your Honor, we would ask that the court deny defendant's no evidence motion for summary judgment.
So it sounds like the portion of the deposition that discussed him paying the fee regularly was not included.
I'm not finding it in the exhibit. It should be included, Your Honor. So I apologize to the court, and I thought it might even be in perhaps it was mislabeled within the motion and be within one of the other exhibits, but he does testify to being a regular rider and paying train fares to ride the DART as a matter of his routine commute. He does not, Your Honor, and I'm not submitting to the court that there is evidence, specific evidence that Mr. Nemens paid a fee on the day of his fall on the platform.
Okay, well that's kind of problematic, Ms. Ramos. So this is kind of how I see it at this point, which is, is it accurate that it's in the deposition that he's a regular rider and he regularly pays his fare? Is that somewhere in the deposition or not?
Your Honor, from my recollection of reading the deposition, which mind you, I have not read it all the way through, Your Honor, in quite some time, but I do recall him saying that he's a regular rider. I'm not sure the portion about whether or not he regularly pays the fee and how he pays the fee is in there. Additionally, Your Honor, this is a plaintiff's second attempt bite at the apple.
No, I get that, Ms. Ramos. Trust me, I get that. So there's a couple ways we can handle this, Ms. Ramos, and I'll kind of leave it up to you. Is, if they'd included that attachment, I would in all likelihood deny the summary judgment, although I do think it's a close call even with that. The fact they didn't include that and it's not clear, you don't remember, and Ms. Webb doesn't have is I can grant the summary judgment. I will tell you just in full transparency that in all likelihood, I would go ahead if they filed a motion to reconsider or motion for new trial, and it does contain what Ms. Webb says it contains, I will probably grant that. So it's up to you if you want her to kind of jump through those hoops. I get that. I understand why you're frustrated. I'm frustrated too. But I'm just going to leave it up to you. What do you prefer? Do you want me to grant it today and then understanding that if they do submit that, I'll probably reconsider, or do you want to just kind of let this move on to the next step?
Yes, Your Honor, I would prefer if they get granted, and if they have that, if it contains that, then go through that process.
That's fair. Okay. Did you submit an order on that?
I believe so, Your Honor. If not, I can get that filed today.
Why don't you go ahead and get that, share that with Ms. Webb. Go ahead and make sure that it says at the beginning that this was heard on November 14th and 2022, and try to get that into me by tomorrow morning.
Yes, Judge.
Thank you, guys. Have a great rest of your day.
Thank you. May we be excused?
You may.
Thank you, Judge.
Okay, next hearing is on DC 21-16560 Bush v. Holloway. Counsel, are both sides here on that?
Here for plaintiff, Your Honor.
Stephen LeBrock on behalf of defendant On Your Passion LLC, Your Honor.
All right, Tony, let's go on the record on DC 21-16560 Bush v. Holloway. Counsel, make your appearances.
Attorney Kevin Christensen on behalf of plaintiff Charles Bush.
Attorney Stephen LeBrock on behalf of defendant On Your Passion LLC.
Okay, I recall that there was a rather heated discussion at our last hearing about whether or not, I think it was Ms. LeBrock, you were going to withdraw. Is that kind of a dead issue at this point, or are you still going to represent Ms. Holloway?
No, Your Honor, I'd still like to, for the court to grant me withdrawal in this case. Ms. Holloway actually reset the hearing for today on her own without notice to the other parties. Your coordinator let us know, but I don't see her present today.
Okay. Let me just see this real quick. We'll go ahead and sign the proposed order of withdrawal.
Thank you, Judge.
And then what about the motion to dismiss?
Yes, Your Honor. Of course, that was filed by defendants. If Mr. LeBrock has withdrawn and Ms. Holloway is not here, it doesn't appear that there's any defendant representative here to argue that motion. And so we'd request that that motion be denied and attorney's fees be assessed.
Okay. Did you already submit an order on that?
I do not know. I can check the record, but I don't remember filing one myself. But my appearance was after the initial response by our client was filed. And so I can file one immediately, Your Honor.
Okay, go ahead and get that in. And we'll see on the next one, guys. Just that you make sure it says at the beginning that this hearing was heard on November 14, 2022. Email it to Rhonda as well as e-file it and get it to me by tomorrow morning. Okay.
Thank you.
Yes,
Judge.
Your Honor. And in regards to attorney's fees, would you like us to put some evidence on the record so that you have something to rule on? I know that Mr. Bush has done a attorney's fees affidavit that's on file with our response to the motion to dismiss. But I also have some attorney's fees as well that I would like the court to grant as well, if that's possible.
You would need to have a new hearing on that.
Understood, Your Honor.
All right, just get me an order.
Thank you. Thank you, Judge.
Have a great rest of your day, guys.
You too.
You too.
All right, our next hearing is on the motion to transfer. Let's go on the record on DC 21-14630 Rava Kamor versus Texas Health Resources. Counsel, make your appearances.
John Barkus for the movement THPG.
Heather Canny on behalf of plaintiff, Dr. Ravi Kumar.
Your Honor, Corey Sudker, I represent the other Texas Health defendants in this case.
Okay. You may proceed.
Thank you, Judge. Just as a reminder, because I know it's been a couple of months, this is a case in which the plaintiff, Dr. Ravi Kumar, has sued my client, THPG, for breach of contract and some related tort claims arising out of his employment with my client. He filed suit here in Dallas, alleged that venue is proper in Dallas because my client's principal place of business allegedly is here. We filed a motion to transfer venue, proved that our principal place of business is in Tarrant County, and proved up a mandatory venue provision in the contract, which also favors Tarrant County. This is in January. We set up for hearing. They filed a response. They said, we're going to file an amended petition. We're going to add new venue allegations. We pulled down the hearing. We waited for the amendment. It never came. We reset the motion for hearing in September, filed a reply brief on the only pleaded venue allegations. They then filed their amended petition a day or two before the hearing. And they did include new venue allegations saying that all were part of the events giving rise to the plaintiff's claims occurred in Dallas. We had a relatively brief hearing. The court allowed us time to gather evidence to rebut the evidence attached to the amended petition, reset the hearing for today. Last week, we filed a supplemental reply and proved with affidavit testimony that all of the events alleged in the petition to have given rise to his claims against my client occurred either in Tarrant County or Collin County. The decision to hire the plaintiff was made in Tarrant County. All of plaintiff's work for my client was performed in Collin County or Tarrant County. Plaintiff experienced some adverse events during surgeries he performed. Those occurred in Collin County. Those adverse events led to peer review meetings. Those meetings occurred in Collin County. the decision to terminate plaintiff's employment was made in Tarrant County. There is nothing alleged in the amended petition that occurred in Dallas County and that gave rise to plaintiff's claims. Plaintiff has alleged that some of my client's employees live in Dallas County. First of all, that's not relevant to anything. That's not an event giving rise to any claims. With respect to one of those employees, Jim Christensen, the proof is a printout from the Dallas Appraisal District website. And it shows that a man named Jim Christensen, who lives in Illinois, owns a house in Dallas. And they got the wrong Jim Christensen. It's a different guy. I got an affidavit from Mr. Christensen. He doesn't own that property. They've alleged that some of my clients' employees work in Dallas, or at least say on their LinkedIn page that they work in Dallas. That's not relevant. That's not an event that gave rise to my client or plaintiff's claims for breach of contract and tort against my client. The only tie to Dallas is that during his onboarding process, plaintiff went to an address on LBJ Freeway in Dallas to complete the technical paperwork of onboarding, to get his credentials given to him. I think he might have even had to take some sort of drug screening test there. That's not an event that gives rise to his claims against my client arising out of his employment. And it's certainly not enough to be all or a substantial part of the events giving rise to those claims. It is undisputed that the plaintiff, and has not even been alleged, that the plaintiff ever worked in Dallas for my client, even for a day. So their new venue theory that all or a substantial part of the events giving rise to these claims occurred in Dallas is not supported by evidence that they have attached to their response or their petition, and it's contradicted by the evidence that we attach to our supplemental reply. The court should grant on that basis alone. The court also should grant the motion to transfer venue based on the mandatory venue provision in the employment agreement. Mandatory, which favors Tarrant County. Those venue provisions are mandatory and enforceable so long as the transaction in question is a major transaction, which is defined by statute as a transaction involving more than $1 million. And plaintiff signed a contract for a 3-year term of employment. In any given year, it was less than $1 million, but if you do the math, if you multiply two numbers together, both of which appear on the face of the contract, it's well over $1 million. And in their response, the plaintiff cited a couple of cases that they say proves that this wasn't a major transaction, and they're just way off point. The first case they cite, there is no value stated on the face of the contract. The movement in that case attempted to prove that it was a major transaction with extrinsic evidence. That's not what we're doing. The other case they cite was a dispute about coverage, was an insurance dispute, and the alleged $1 million value was derived from coverage limits. And the court in that case very rightly said that the coverage limits in the policy don't represent a major transaction because it was insuring risk that could be far less than that. Here we have clear evidence from the face of the contract that this was a major transaction. Their other response is to say, well, there's a carve out for transactions involving personal purposes, which they say this was. They cite no authority in support of the proposition that an employment agreement between a doctor and a physician's group like my client is a contract entered into for personal purposes. So the court should grant for that reason, as well as the complete lack of evidence that anything that matters to any of these claims occurred in Dallas County.
Response?
Yes, Your Honor. Before I begin, will you please allow me to share my screen so I can use my PowerPoint?
Sure.
Thank you. Can everyone see that?
Yes.
Great.
How are you doing that where you're on the bottom of the PowerPoint? Is that some special program?
It's not. It's actually a Zoom feature, and you just go under. It'll say, I think, basic or advanced, and you can click on advanced. I remember actually teaching Mr. Sutker about this a while back.
I've never seen anyone do that. It's pretty cool.
Thank you. And the trick is not to block your own PowerPoint by the floating head, but Your Honor, I represent Dr. Ravi Kumar in this case. He is the plaintiff. He goes by Dr. Ravi, so if you hear me refer to him as Dr. Ravi, it's the same individual. He is a board-certified cardiovascular and thoracic surgeon. Back in 2018, he was practicing in Arizona, and executives at Texas Health Resources, THR, which is another one of the defendants in this case, represented by Mr. Sutker, began recruiting Dr. Ravi to come to North Dallas to establish a new robotic valve surgery program in order to compete with the other hospitals, hospital systems in North Dallas that provided such services for their patients. So defendant THR is not, they do not have a motion to transfer. Well, they have a motion to transfer venue. It's not pending today. The only pending motion is by THPG, which stands for Texas Health Physicians Group. And that's the non-for-profit health corporation that employs all of the physicians and other medical professionals for THR. So, and we've, Dr. Ravi Kumar has alleged numerous causes of action as to both THR and THPG in this case. Without getting too far into the details of the actual petition, Dr. Ravi was recruited by THR to come to North Texas, North Dallas, and start this new robotic valve surgery program. Even after he, as soon as he got there, he began being subjected to prolonged peer review and was ultimately terminated from his employment. And he seeks damages in this case for the violation of THPG and THR's corporate practice of medicine, improper restraint of trade, tortious interference with contractual relationships, breach of employment agreements, and business disparagement, among other causes of action. So Texas law grants plaintiff the first choice of where to file a suit. That's long been established. And Dr. Ravi exercised his right to choose the forum in which relief was sought for his claims in this case, and that is Dallas County. It's where a substantial part of the events and omissions giving rise to this lawsuit occurred. And it's where defendant THPG maintained a principal office at the time. And I'll note that there's been a lot in the briefing about how that office has since no longer has ceased to continue operating there in Dallas because of the tornado. But I'll point the court to Texas Civil Practice and Remedies Code 15.006, which says venue of suit is based on facts existing at the time the cause of action, that's the basis of the suit, accrued. And at the time of the recruitment efforts and the signing of the employment agreement and the beginning of his employment, THPG did operate their principal office at this Dallas location. Since Dr. Ravi Kumar has established venue as to at least one of the defendants, this court, as you're aware, has venue over all of the other defendants. And as set forth in our response brief, Dr. Ravi Kumar has certainly made a prima facie showing that venue is proper. in Dallas County, and that choice should not be disturbed. Dr. Ravi Kumar filed his first amended petition back in September of this year, September 23rd of 2022. The following Monday we're supposed to have this hearing. Counsel for THPG requested that they had additional time essentially to investigate the information in the first amended petition, although it was the exact same information that had been in our response to the motion to transfer venue for months and months. I'll note that as of today, defendant THPG has not even filed an answer as to plaintiff's first amended original petition. They haven't denied any of the allegations set forth in plaintiff's first amended original petition, and they've certainly had adequate time to do so. So in 2018, and again, venue is proper in Dallas County. Beginning in 2018, THR executives began recruiting Dr. Ravi Kumar to North Dallas to start this robotic valve program. On several occasions, Dr. Ravi met with THR and THPG executives, employees, etc., in Dallas County to discuss the opportunity. He negotiated the terms of his contract in Dallas. He was given information pertaining to THR Plano and THR Dallas patient caseloads pertaining to cardiothoracic surgeons. He relied on those representations of the caseloads in those hospitals, THR Presby Plano, THR Presby Dallas, when entering into his employment contract. THR requested him to go through the credentialing process at THR Dallas Presby in an effort to establish their new robotic valve program there. He was also required to go to their quote, and this is their words in an email, which we've attached in our response, to go to their Dallas office in order to meet with the executives and to complete all onboarding requirements. On December 10th of 2018, defendant THPG hired Dr. Ravi Kumar. Going to the next slide, I set forth, Dallas County is a proper venue under 15.002B of the Texas Civil Practice and Remedies Code. The court should not disturb plaintiff's venue based on 15.002B or 15.020. Dr. Ravi Kumar has satisfied his burden. He's pled that under 15.002A3, THPG maintains a principal place of business in Dallas. He's also pled that a substantial part of the events or omissions giving rise to the cause of action occurred in Dallas. And then in our response, we've attached the affidavit of Dr. Ravi Kumar. And in his affidavit, Dr. Ravi explains how all of these recruitment efforts took place for him to come to North Dallas, beginning in the spring of 2018. In June of 2018, James Parabek, who was at the time the executive vice president of physician enterprise at THR and is now the president of Texas Health Dallas, emailed Dr. Ravi Kumar to discuss his employment. At all times, Mr. Parabek resided in Dallas. Thereafter, in 2018, also the same month, Mr. Christensen, the executive director of physician development at THR, emailed Dr. Ravi to tell him that he'd been working with Jim Parabek and other senior officials. At all material times, Mr. Christensen listed Dallas at his workplace on his public LinkedIn profile. Going forward, in August of, or actually in July of 2018, again, they were sending emails to Dr. Ravi Kumar, ensuring him and reassuring him that there would be enough patient caseload in Dallas and Plano. They gave him information on Dr. Poole and Dr. Hill's patient caseloads in Dallas to assure him of those representations. And in August of 2018, Mr. Christensen emailed Dr. Ravi Kumar to let him know that Sarah Garten would be assisting with credentialing with THPG and Texas Health Plano. At all times, she's listed Dallas as her employment in her LinkedIn profiles. And going on to the next slide, in October of 2018, Cora Bennett, the executive director for integration and training at THPG, emails Dr. Ravi Kumar regarding the onboarding program. And as set forth in her email, Dr. Ravi Kumar was required to attend several mandatory in-person onboarding meetings at THPG's Dallas office as a condition before even obtaining employment. In October of 2018, Steve Hadzima, who's the CMO of THR Plano, followed up, emailed, and stated that he wanted Dr. Ravi Kumar to go ahead, to move ahead with obtaining privileges at Texas Health Dallas. He states, in regards to Texas Health Dallas, we believe moving ahead with privileges there makes sense. And so Dr. Ravi Kumar did. In November of 2018, Jeremy Noor, who's the executive director of operations for THR, emails Dr. Ravi Kumar and asks Dr. Ravi to, quote, come to the Dallas office. Interestingly, it was Dr. Ravi's understanding that Mr. Noor was the executive director of operations for THR, although in his signature block, he states that he's the executive director for THPG. Pursuant to that request, Dr. Ravi Kumar goes to the Dallas office located at the address included in that correspondence. He did all of his onboarding work there. He completed his employment paperwork there. He did all of the necessary lab work testing to begin employment at the Dallas office. And in December of 2018, he enters into the employment agreement with THPG. And that employment agreement entitled him to an annual salary for the first 3 years. It was $1 million per year. And at no point in time did Dr. Ravi Kumar ever sign or execute an employment contract with THPG in Tarrant County. At no point in time did he ever provide medical care services to anyone in Tarrant County. THPG has asserted both today and in their briefing that the court should enforce a mandatory venue provision under Texas Civil Practice and Remedies Code 15.020. And they seek to state that this employment contract was a major transaction. However, they have not met their burden of proof required for a transfer based on that major transaction. Contrary to THPG's counsel's representation to the court that this was a $2.1 million contract, the employment agreement does not have an aggregate stated value equal to or greater than 1 million in the primary term. And in order to be a major transaction, Section 15.020 requires the agreement in question to have an aggregate stated value equal to or greater than 1 million. And you don't look at the aggregate, you look at the yearly payment required. And we've cited the case law that supports that. Even most recently in Austin, the Austin Court of Appeals has stated that agreements are not a major transaction when the total possible payments are over 1 million, but or contingent upon future employment, future sales, et cetera. And the very same thing is true here. Dr. Ravi was to receive a base salary of less than $1 million. The terms are stated in his employment contract, which is on file with this court. The agreement states that it can be terminated pursuant to a clause allowing termination with or without 180 days written notice, which in fact that was given on December 11th of 2019. On its face, the agreement has never been over $1 million, but it's, doing the math, Dr. Ravi Kumar never received $1 million at any point in time from his employment. In fact, he was paid less than $500,000 by Texas Health Resources and THPG in both years. And so he never received even close to the 1 million in aggregate compensation. We've also provided information for the court that this transaction was entered into for personal reasons. It's not a B2B, business to business transaction. This contract between Dr. Ravi is for a single individual, Dr. Ravi Kumar, individually, not a business or even a professional association. It was him individually entered into an employment agreement in order to earn a living and to provide for himself and his family. Moving on, we would also show the court that defendants have not set forth any sort of forum non-convenes argument in their motion, so I don't think we need to address that point. But overall, continuation of the suit in Dallas County is proper. It is a proper venue in which to file this suit. No mandatory venue provision applies, and Dr. Ravi Kumar has certainly met his prima facie burden to keep suit in Dallas County. And for those reasons, we would request that the court deny THPG's motion to transfer venue to Tarrant County, where absolutely no facts or events giving rise to this claim occurred. Thank you.
Any reply?
Yes, Judge, briefly. On the mandatory venue issue, if Ms. Canny's argument and the plaintiff's argument is the court shouldn't multiply two stated numbers together to derive the aggregate value of the contract, there's certainly no authority for that they've cited. They've also cited no authority defining what a personal contract is or saying that it must be a business to business contract to be within the mandatory venue statute. On the issue of whether this place of business on LBJ Freeway existed, Ms. Canny is correct that under section 15.006, it's measured at the time the cause of action accrued. The cause of action accrued when the plaintiff was fired in December of 2019. We put in evidence with our original motion that the building was destroyed by tornado 2 months before that. It wasn't there when the cause of action accrued. And with respect to all of these things that Ms. Canny went through on her slideshow, alleging that this or that or the other happened in Dallas, every single one of those events allegedly happening in Dallas occurred before Mr. Ravi Kumar's employment began. And there is no cause of action among the 12 asserted in the First Amendment petition arising out of any alleged misrepresentations that occurred during those conversations or meetings. Those meetings and those conversations and those emails do not give rise to plaintiff's claims. And I would note, and I think I'm done on this, Dr. Ravi Kumar in his affidavit does not say that he signed that employment agreement in Dallas. In fact, he very carefully doesn't. He says, I didn't sign it in Tarrant County. My belief, and I certainly don't have evidence of this, is that he signed it at his home in Arizona. But if he had signed it in Dallas, he should have said that, and he didn't. And I think that's intentional. For all of those reasons, I think the arguments that Ms. Canny has advanced do not change the conclusion that this court should reach, which is that venue is not proper in this county and should be transferred to Tarrant County, which is a county of proper venue. Thank you.
Okay, I'm going to take this under advisement. We'll try to get you ruling the next couple weeks. Okay.
Thank you, Judge.
Thank you.
Thank you. And I think our last hearing of the morning is Martinez versus Ford Motor Company. Is everyone here on that?
Yes, Your Honor.
Yes, Your Honor.
Yes, Judge.
Let's go on the record on DC 21-18375, Martinez versus Ford Motor Company. Counsel, make your appearances.
Lauren Subar on behalf of the plaintiffs, Your Honor.
Deborah Bullion on behalf of Ford Motor Company.
Bill Minucci for Ford Motor Company as well.
Akeem Ayende for the movement in the city of Grand Prairie and the Grand Prairie Police Department.
All right, so we have an interesting provision here saying that body cam footage is not discoverable. I've never heard that argument before. So what is, read one side's briefing on this. What's the response?
Your Honor, we filed a response last week, but this begins, Your Honor, first of all, with regard to the Texas Occupation Code 1701.661 actually begins with a reference to actually a different provision, Your Honor, which is Texas Government Code 551, which essentially says, first of all, that public records should be available to the public. Now then, with regard to that, the courts have said, the statute, first of all, says that some documents may in fact have some privacy provisions that are otherwise protected. The Texas Supreme Court has looked at that provision in Industrial Foundation of South Texas versus Texas Industrial Board, which is 540 Southwest 2nd, 668 at 681-82, and said there's essentially two parts to the test with regard to whether something is actually protected with regard to privacy. The first of those, Your Honor, is that the information to be protected has to be highly intimate or embarrassing, has to contain highly embarrassing or intimate facts about a person's private affairs, such as its publication would be deemed objectionable to a person or of ordinary sensibilities. And the second provision is that it has no legitimate purpose to the public. And both of those provisions have to be met, Your Honor. The reason why that section, that section of the government, Texas Government Code 552.101, is specifically mentioned in the Texas Occupation Code is because that's what you have to look at when you're looking at the protection provided under 1701.661 661F, and I will slow down. I always talk too fast, and you know that, Judge Hoffman. I will slow down. So let's look at 1701.661F under that understanding. Under the understanding that information that is highly intimate or embarrassing with regard to facts of a person's private affairs should be protected. And you look at the language of that provision, and it says that the protected recordings are those for the investigation of conduct that constitutes a misdemeanor punishable by a fine only and does not result in arrest from a person who is the subject of that portion of the recording. And those are two important things, Your Honor. First of all, from a global standpoint, needless to say, there are a lot of things that people do that where the police show up, things like public intoxication, those kinds of things that are clearly the public intoxication is a misdemeanor, and having that kind of video information out there where it's publicly available certainly could be embarrassing with regard to that person's private affairs. But here's what we're talking about here, Your Honor. We're talking about a driver's license. Their argument is that the misdemeanor is a driver's license and insurance. Well, needless to say, neither one of those would be the types of misdemeanors that would lead somebody to be embarrassed about private facts with regard to their private affairs. But, Your Honor, that's not even the biggest problem with Grand Prairie's reliance on that statute, and that is that we're talking about 11 videos, and if you read their motion, if you read the Grand Prairie's motion, they say that their concern is that the non-party persons appearing in 7 of the videos have not signed releases. But, Your Honor, the statute makes it very clear that the only person whose information is protected is, in fact, the subject of that portion of the recording. Certainly, it does not cover all of the people in the background because they are not the subject of the investigation. In this case, Your Honor, the only person that was the subject of the investigation is, in fact, the person who did not have their driver's license and did not have their insurance, and that person is not a non-party, which means that the city of Grand Prairie is asking for protections that clearly are not covered under the statute because those non-parties are not subject to the investigation. The only person subject to the investigation is not somebody that the city of Grand Prairie has even indicated that would be protected under their view of the statute. And needless to say, they have said that even with regard to that, only 7 of the videos even have that information, have not given any explanation why, if there are 11 videos, that even the videos that are not a part of their motion have not been produced. But the fact of the matter is, Your Honor, under their argument and under the statute and under the law, none of those videos are protected from being produced with regard to the subpoena that was served on the city of Grand Prairie. And again, Your Honor, we did file a response on Friday afternoon, and if necessary, Your Honor, before the court rules, because we go through a lot of the same facts and information. I certainly would want the court, if necessary, to be able to have the opportunity to look at that video. I will throw one more thing, Your Honor, out there, and then I'll be done. And that is that one of the things that's discussed in that brief is the fact that the courts have made it very clear that when you are dealing with statute interpretation, it has to track the language of the statute, Your Honor. And under the argument put forth by the city of Grand Prairie, that any time that the issue is something even dealing with something like a driver's license or insurance, that means that every single video from every single accident, whether it has the subjects in the video or not, would be protected from production, because as the court knows, one of the things that is in every single crash report is proof of insurance and proof of driver's license. And that certainly could not be the intent of the legislature with regard to the language that the legislature felt necessary to put into this statute, Your Honor. And for those reasons, the plaintiffs and I'm sure that the Ford folks may have their own argument as well, but we did file this jointly, would request that the motion put forth by the city of Grand Prairie be denied, and that those 11 videos be produced. Thank you, Your Honor.
Your Honor, on behalf of Ford Motor Company, we did join in and we do join in the arguments made by plaintiff's counsel. I've been doing this for over 30 years. Dash cams and body cams haven't been around that long, but ever since they have been, and routinely, this is the first time I've heard someone move to quash them and not produce those videos, which can provide vital information for both sides, plaintiffs and defendants, in understanding the crash, understanding what happened. And I would just add one thing with their argument in terms of they didn't get releases from people who may have appeared in the body cam. It is routine, whether it's DPS or the state police, when they're investigating, may add to their report an actual written statement from a witness. They may summarize what that witness said, and I'm not aware of them ever getting a release in order to put that in a report. So I'm not fully understanding why they need a release for someone just to tell the police, hey, this is what I saw, or I was not here at the time, but I rendered help or aid. So we would join in with the plaintiffs in terms of their request that the motion to quash be denied and we be provided with the body cams from the Grand Prairie Police Department.
Response?
Yes, Judge. I believe that section 1701661 of the Texas Occupations Code, section F, is pretty clear. It's carved out as law enforcement agency may not release any portion of a recording made in a private space or recording involving the investigation of conduct that constitutes a misdemeanor punishable by fine only and does not result in arrest without written authorization from the person who is the subject of that portion of the recording. Now, in this particular case, this is an investigation of a vehicle crash accident where the police did interview multiple witnesses. This isn't just somebody walking by and the police department recorded it. No, they actually recorded witnesses who seen the crash, witnesses who were in the car with one of the parties, and this 7 different videos where they are actually interviewing witnesses for their investigation of the crash accident. And during that crash, after they concluded their investigation of the crash accident, they did issue 2 citations, I believe, to one of the parties of the particular case with no driver's license and no insurance, but no arrests were made at the scene, Your Honor. And so to me, it's just pretty laid out, pretty clear fact that section F, it states that, hey, if it constitutes as a misdemeanor punishable by fine only, does not result in arrest without any type of written authorization from people who are subject to the portion of the recording, that this may not be released. Your Honor, we did not receive any written authorizations from people that were in that particular recording of the body worn camera. So we believe that it is our duty to object to the subpoena, Your Honor. And we just ask that the court do release all liability or all obligations from us pertaining to the information that is governed by section 1701.661F.
All right, the motion to quash is denied, but I do want to have included in here that this is only going to be used for this litigation. It will not be posted on the internet or anything like that. All right, guys.
Thank you.
Thank you.
Let's give Mr. Subar, if you can go ahead and prepare that order, share it with Mr. Allende and other counsel, and make sure it says at the beginning that this of the order that this was heard on November 14th, 2022, and